The hearing is in the matter of CFI 95/2022 before Justice Wayne Martin. The claimant is represented by the Allied Ross and the lead counsel is Mr. Scott Hudson. The fourth and third proposed defendants are represented by Khairallah Legal, and Ms. Jocelyn Khairallah will appear on their behalf. Thank you very much.
Thank you. All right. Mr. Hutton.
Thank you, my lord. And again, good afternoon and good afternoon to my colleagues. Can I start by asking, my lord, whether you've had the opportunity to read the skeleton arguments?
I have. I've read the skeleton arguments, and I've read the witness statements, and I've read most of the documents.
Excellent. So, thank you.
But before we go any further, I take it the first and second defendants are not represented here today.
I don't believe so. Perhaps my colleague may know more.
Well, she would know. She's not acting for them. She's acting for the prospective third and fourth defendants. So, yeah, all right. All right. So the first, there's no appearance from them today. All right.
Okay. So I do not propose then, my lord, to take you through all of the background here, but rather focus on the key points for today's hearing.
Yes.
And I think worth pointing out at the start that this entire case is based around obligations owed by the first defendant to the third, or the proposed third defendant. Now, those obligations were then assigned to the claimant, and that's what brings us here today, as the claimant would like to join the proposed defendants for clarity and to assist the court. So in summary, our submission.
Well, you say for clarity and to assist the court. I mean, you need to go, I think, further than that.
Well, if
you're going to take me to the rule under which you apply in due course, I assume?
Yes, my lord.
Yes, all right. We'll come to do that when we come to it.
Sure, thank you. So our submission be dealt with in two parts. The first part being that it is desirable, necessary, and efficient to add the proposed defendants to the existing proceedings in order to resolve all matters and all issues in dispute amongst the claimant and all of the defendants and the proposed defendants in one set of proceedings.
What's the dispute between the claimant and the existing defendants? Can you help me with that?
It's for a declaratory, or an order for declaratory relief, my lord, to clarify obligations owed by the claimant to the first defendant.
Well, is there any dispute? But where's the evidence of a dispute between those parties with respect to those obligations?
Well, what we have now is proceedings in Dubai courts where the proposed defendants have challenged the amounts.
I'm not talking about the third and fourth defendants. I'm talking about the first and second defendants. What is the dispute between them and the claimant? And where's the evidence of that dispute?
So in the application, or the case for declaratory relief, my lord, now I apologise if I frustrate you here, but the application was for declaratory relief to confirm the amounts owed by the claimant.
I've read the claim. My question, though, is what is the dispute? Is there any evidence that the defendants dispute the claimant's claim? Because I haven't seen any.
Between the claimant and defendant, no, I don't believe so. And perhaps, my lord, if I may clarify something, I've been brought into this very late due to an unfortunate accident, I believe, with my instructing firm, or with the instructing counsel. So I only come into this weekend, so I cannot give you accurate or clarity perhaps on what has gone before.
Well, it's fairly important, because if there is no dispute between the claimant and the first and second defendants, there's no justification for joining additional parties, is there?
Well, there seems to be a lack of clarity as to the amounts that are owed between the parties and what obligation was assigned.
But is there a dispute between the claimants and the first and second defendants as to that? I understand there's a dispute between the third and fourth defendants and the claimant, because that's the subject of Dubai proceedings. But you're trying to use the proceedings which have been commenced by the claimant against these defendants as a hook to bring the third and fourth defendants into this court. And now, of course, the premise of that is that there is in fact a dispute between the claimant and the first and second defendants. And I just want to see what the evidence of that fact is. But because I've read the particulars of claim and the declaratory relief, of course, you won't get declaratory relief unless there's a real controversy between the parties. And I haven't seen any evidence of any actual controversy between the claimant and the first and second defendants. But if there is some, take me to it.
Well, all I can tell you there, my lord, is that it is accepted that there is a debt owed to the first defendant, but that amount is now uncertain, and we're seeking clarity from, or declaratory relief from the court as to that amount.
Why is it uncertain? Where's the evidence of uncertainty?
That would be in the Dubai courts case, my lord, where...
Well, the Dubai courts is a case between the third and fourth defendants. I'm asking you, what is the evidence of uncertainty of the amount owed as between the claimant and the first and second defendants?
I understand that the Dubai courts case now also involves the first defendant and alleges that a different amount is due. So the declaratory relief sought here is in relation to the amount due. Well,
but again, I think with respect, you're not answering my question, which is what is the evidence of a dispute between the claimant and either defendants as to any obligations or amount due?
I'm afraid, my lord, I can't answer any better than I have.
Well, you've got a problem. Well, that's a problem for you, isn't it? Because you apply under Part Order 20.7, which provides that a court may order a person to be added as a new party if it's desirable to add the new party so the court can resolve all the matters in dispute in the proceedings. So you've got to show that there is a dispute in the proceedings. And I can't see that there is a dispute in the proceedings. Well, if there is, you can't. I haven't been able to spot it, and you can't show it to me. That's a bit of a problem for your reliance on Order 20.7, isn't it?
I understand your position there, my lord, but I'm always reluctant to go down this route, but I am instructed to appear in relation only to the joinder application.
Well, that's what I'm asking you about.
Yeah,
because I don't. With respect, Ms. Corelli can tell me if this is wrong, but I think the jurisdiction application is with respect premature, because unless and until the third and fourth defendants are joined, the court isn't exercising jurisdiction in relation to them.
100% correct, Your Honor.
Yes, and so, but of course, Ms. Corelli, you can rely upon your arguments that the court lacks jurisdiction in relation to those defendants as a ground for resisting their joinder. But I think it's all tied up. The only real question is whether they should be joined, and that involves jurisdictional issues as well. But that really turns upon Order 20.7, RDC 20.7. So, Mr. Hutton, back to you. How do you answer this?
In relation to your point on dispute, my lord, I'm at somewhat of a loss, other than it seems that there clearly is a dispute about the amount owed.
But between who? The dispute between who and who?
Granted, that's between the proposed defendants and the first defendant, but that also impacts the claimant, because under the assignment agreement, that obligation is passed on to.
But that doesn't mean that there is a dispute between the claimant and the first defendant, does it?
Well,
you see, it said, let me put this to you too. It said that the first defendant is a company in which the only shares are held by the second defendant. And it's also said that the claimant is a company in which the only shares are held by the father of the second defendant. Now, is that correct? Does that coincide with your instructions, Mr. Hutton?
Yes. Yes, sir.
Well, then there's got to be a question, given those relationships, got to be a question as to whether there really is any dispute between the claimant and these defendants, isn't there?
I do understand your position there. However, with respect, I do feel that there is a dispute now because there is no certainty on the amount owed. And
yes, but that's because of the issue raised by the third defendant or the fourth defendant or whoever it is. But there is no evidence before me that they're not here today, either the defendants. There's no evidence before me that they contest any of the allegations made by the claimant. And let me be blunt, Mr. Hutton, that this is the Nest jurisdiction using Order 20.7 is somewhat controversial, as you might be aware. And that's the decision in Nest basically was that because Article 5A of the Judicial Authority Law provides that the court has jurisdiction under any law of the DIFC, the rules of court are laws of the DIFC, therefore joinder, if the court has jurisdiction to join parties under 20.7 and those parties are roped into the court's jurisdiction, whether or not they would otherwise be amenable. So what that means is that parties to a dispute before this court, the DIFC court, can bring other parties in. And those parties can't assert the court lacks jurisdiction because if joinder can be legitimately made under Order 20.7, then the court has jurisdiction by definition, according to the Court of Appeal in Nest, by which I'm bound, of course. But that presumes that there is a legitimate dispute on foot between the proceedings in the DIFC court to which additional parties are properly joined. If there is, in truth, no dispute between those parties, then the commencement of the proceedings in the DIFC court is nothing more than a device by which to try and give jurisdiction to this court, which it doesn't really have in relation to the real dispute, which is between one of the parties to the original proceedings and someone else. So in order to prevent that sort of, well, frankly, I think it would be an abusive process. There's no other way to describe it, I think. To prevent that, one has to, I think, inquire as to whether there is indeed a legitimate dispute between the parties to the proceedings in this court to which the proposed parties are appropriately joined, either because there's an issue involving the new party and the existing party that's connected to the matters in dispute or whatever other reason. But you can't answer any of those questions under Order 27 unless you know what the dispute is. Well, and I can't see, on the evidence before me, I can't see any dispute between the claimant and the first and second defendants, and that's reinforced by the fact that they are effectively father and daughter.
Yes, well, I don't dispute any of that. However, what I would say is that the remedy sought here is declaratory relief.
Which you won't get unless there's a real dispute. The court doesn't give declaratory, an English court wouldn't give declaratory relief just because parties come along and say we want a declaration. The court, as you know, a precondition to the grant of declaratory relief is that there be a legitimate dispute, which the court will quell by granting declaratory relief.
Which there clearly is now.
But between which parties? You see, if you go to the declaration that's in your particulars of claim, as I had it there. Now, just let me pull it up again. The screen's gone off.
Yeah, I've got it here.
It's a declaration that the accountable sums is as stipulated in the audit confirmation sheet executed by Mr. Paksharajan. Now, that's the dispute about whether Paksharajan, if that's how you pronounce it, signed the audit confirmation sheet. That doesn't seem to be a dispute between the claimant and either of the defendants. And then the second declaration is to the extent that any of the amounts mentioned in the audit confirmation sheet were paid by Mr. Paksharajan personally, those payments were paid on behalf of 4U Impex. Now, again, that seems to be an issue as between somebody, probably the claimant, and Paksharajan. And then the third issue is the obligation of Gold CA to repay was assigned to the claimant by way of the assignment. Now, that appears to be a dispute between the defendants, but there's no evidence that either the defendant asserts that there wasn't an assignment. So there doesn't, I just can't see any evidence of any dispute between the claimant and the defendants, the existing defendants.
I, again, understand entirely what you're saying, but the position we would take there is that there is clearly now a dispute amongst the defendants as
well, no, but yeah, but that presumes, I mean, that's an entirely circular argument. You're saying because there's a dispute between the claimant and these additional parties, therefore there is a dispute. But you only get in under 20.7 if you can answer the tests posed by that rule in relation to the dispute that is before the court.
But,
so if you go to 20.71, so they can resolve the matters in dispute in the proceedings. Now, that must be the existing proceedings. So you can't answer that question unless you know what is the dispute in the existing proceedings.
If, I mean, my lord.
Same with the second question. There's an issue involving new party which is connected to the matters in dispute in the proceedings. Well, unless you know what the dispute in the proceedings is, you can't answer either of those questions.
Well, the dispute...
And you can't tell me what the dispute is,
well,
as between the claimant and the defendants.
I would suggest, my lord, that there is clearly there is a dispute in terms of the obligations owed by the claimant on account of the defendants by virtue of the assignment agreement. So if the position argued in Dubai courts is found to be correct, then the amounts owed by the claimant to the defendant have changed, and therefore there is a dispute about the amount.
But there is no current dispute between the claimant and the defendants. The claimant and the defendants have a common position in relation to that. They say what's being said in the Dubai courts is wrong. So it just looks to me like this is an attempt to try and muscle the proceedings out of the Dubai courts into the DIFC courts, when there isn't really a dispute between the parties to these current proceedings. That suspicion is exacerbated by the fact that the parties are in truth a father and a daughter. There's no evidence of any dispute between the claimant and the defendants. The defendants aren't here today, and the application for joinder was made 3 days after the proceedings were started. So it rather looks, there is an inference, I think, Mr. Hutton, to the effect that this was part of a strategy designed to create what appears to be create the appearance of a dispute to which the third and fourth defendant parties could be joined, so as to give this court jurisdiction over the real dispute, which is with those parties.
Well, certainly my instructions are that is not the intention. The intention here is to obtain a relief that is not available in the local Dubai courts, and that is
against whom? Against whom?
Declaratory relief in relation to the amounts owed as a result or owed by the claimant to the proposed defendants under the obligation assigned from the first defendant to the claimant.
Do the defendants dispute the amount owing to the claimant?
They do now, as a result of, it was understood that it had been agreed, but that is now in dispute.
Between who? Between the claimants and the defendants?
Well, ultimately between the claimant and the defendant, yeah.
Well, where's the evidence of that?
I do accept that hasn't been, nothing's been submitted, or that's always been submitted there, my lord.
Well, if you can't produce any evidence of a dispute in the proceedings, I don't see how you can answer the question posed by RDC 20.7 in the current proceedings.
But forgive me, my lord, but as this is the claim is for declaratory relief, which is not available elsewhere in this.
I understand that, but even in a common law court such as this, you'll only get declaratory relief if there is a genuine dispute between the parties as to whether the relief should be granted. So courts just don't give friendly parties declarations because they come and ask for them. the court will decline to exercise jurisdiction unless there is a genuine dispute between the parties seeking declaratory relief. And so I just think it all comes back to the same question. I just think you need some evidence that there is in fact a dispute.
I'm afraid I can't offer an awful lot more, my lord, other than to say that looked at from above, if you like, from a high level, there is a dispute as to the obligation owed, and that requires clarification, which is what is sought here. And what is sought here is not to create a full DIFC proceeding around the whole circumstances, but rather to get this relief that is not available in the Dubai courts. So there is a dispute as to the amount owed under the original obligation, and that original obligation has been assigned to the claimant, and therefore the claimant is almost by extension involved in that same dispute.
Well, is the claimant a party to the proceedings in the Dubai court?
It's not, no.
Well, then it won't be bound by the decision of the Dubai court. So then it'll all turn upon whether the defendant wishes to rely upon the decision of the Dubai court or not. We don't know that because it'll depend on, we don't know what the Dubai court proceedings will determine.
And
so
then
if the defendant wins the Dubai court proceedings, then there is no issue.
And we potentially end with a situation where there is a different amount owed under the assignment agreement as is deemed to be owed, than is deemed to be owed from the first defendant to the proposed defendants.
Well, that's the risk that you take when you take an assignment of an obligation. If you take an assignment of that obligation, if the obligation is more or less, then that's the risk you take. But it doesn't mean that there is currently a dispute between the claimant and the first or second defendants. Because we just don't know what the position of the first and second defendants is in relation to their obligations under the assignment agreement.
Yeah, and no one here can talk to that.
No one here can talk to that. So I just... Is there anything else you want to say, Mr. Hutton?
Given your comments so far, I don't think it's worth discussing going through Rule 20.7 and NEST on this basis, because there seemed to be almost a preliminary.
Well, feel free. I'm certainly not shutting you down, but tell me how you would apply Rule 20.7. That's what I'm interested in, because unless you know what the dispute in the proceedings is, I don't know how the rule applies. So if you want to take me through what you were going to say about that, that might be helpful.
Yeah, well, look, if you're willing,
yes,
that would essentially involve an understanding that our position is that there is a dispute between the first and second, the claimant and defendant, based on the amount owed, and that is right. The dispute. And I almost use air quotes there, which I hate to do.
Well, that's not a dispute that would be resolved by the declaratory relief that you seek, is it?
Well, it would confirm for our purposes the amount that is due and owed under.
Well, which of the three orders you seek would confirm that?
So the audit confirmation sheet confirms the amount owed, the amounts paid.
Well, the amount due is the amount due under the assignment agreement. The parties to the claimant is obliged by reason of the assignment agreement.
Yeah, which ultimately comes back to the audit confirmation sheet. That's the underlying document for the settlement agreement.
Well, can you take me to the assignment agreement and make that proposition good?
Let's have a look. So the assignment agreement is at D103 and D104 of the bundle.
So what was that again?
D103 and
D for Daniel?
D for Daniel, yes.
Yes, all right. D103.
Yeah, this is the translation.
Yes.
And at paragraph 1 there refers to assignment of the obligation to repay the sum of 3.7 million dirhams to 4U Impacts as calculated in the attached audit confirmation.
That's all right.
And
but the amount is specified in the assignment agreement. It's 3.7 million.
Yeah, agreed. Based on so if the underlying document as calculated in the audit confirmation, if that is incorrect, then.
Well, does the first defendant say that the amount is incorrect?
I can't comment on that, I'm afraid.
Well, we get back to the same problem. The third defendant, the fourth defendant says that he never signed the audit confirmation sheet. But that's a dispute between him and somebody else. That's not a dispute between him and the claimant.
Our position there would be that it directly affects the claimant, and the claimant, all the parties should be involved in resolving those issues, which is what is sought here effectively, to get all the parties in here into this proceeding to work out exactly what is owed to and by whom.
Well, but that's the amount that is owed by the first defendant to, and assuming, I mean, I can't see the first defendant anywhere on this assignment agreement. Where's the reference to the first defendant? This is an agreement.
First defendant. So this assignment contract is entered into between Gold CA.
Yes, and Playa Leona SA. Well, who's that?
Yeah. So that is the translation of the claimant. So that is translation of Sociedad de Inversiones y Desarrollo, Playa Leona SA.
All right.
Excuse my pronunciation.
Okay. Yes, all right. But again, well, I'll just be repeating myself.
Yeah, I understand. And my lord, if I may, the position we're at the moment, the arguments I had proposed to present to you all relate to jurisdiction under 20.7 and the Nest case. And if none of that is going to deal with this underlying dispute issue.
All right. Well, I think it is you understand the point I'm making. I just can't see that there has to be an existing dispute between the parties to these proceedings to justify the joinder of somebody else. And there's no evidence before me that there is any dispute between the claimant and either of the defendants. What is clear is that they appear to have a dispute with somebody else. But that doesn't mean that you can commence proceed. It doesn't mean, let's talk bluntly, parties who are friendly to each other can't commence proceedings in this court and then use that as a hook to drag somebody else in who has no connection with this court or these or its jurisdiction.
And I think this is where we're at, somewhat at odds, in that the argument for the claimant is that perhaps there is certainly an uncertainty now as to the value of the debt owed.
Uncertainty as between whom?
As between the claimant, the first defendant, and the proposed defendants.
Well, I can understand there's uncertainty as between the first defendant and the proposed defendants, But I don't understand why there's uncertainty as between the claimant and the defendant, because the agreement says that the claimant will assume the obligation to pay AED 3.7 million.
Yeah, as calculated in the audit confirmation sheet. So we would argue that if the underlying calculation is wrong, then that figure has to change.
Well, but you would argue, but does the defendant argue that against the claimant? I haven't seen, there's no correspondence to suggest that that's the position of the defendant. There's no correspondence, there's no evidence there's any hostility or controversy between those parties at all. Again, we've been around and round on that. So.
Yeah, and I wonder if I may, as we're dealing remotely, I don't have the benefit of my instructing solicitors
Would
here
you like,
with
would
me.
you like a brief adjournment?
I was just going to suggest perhaps I could give them a call.
Yes, by all means. How long would you like? 10 minutes?
10 minutes should be plenty.
Yes. All right. All right. Well, we'll just leave the line open, but perhaps turn off the sound and the camera, and we'll resume at 20 minutes to the hour.
Perfect. Thank you, Lord.
Minutes. All right. Thank you. Yes, Mr. Hutton.
Yeah, thanks, sir. And thank you for that indulgence. I've spoken to instructing counsel, and all they can point to at this stage is, or they stress that it's very early stage in the proceedings for declaratory relief as well, and all that's been submitted so far is the acknowledgement of service on behalf of the defendants, first defendants, and second, confirming that
I haven't seen it. The only acknowledgement I've seen on behalf of the second defendant is one filed by Ms. Corella. I think there's been two acknowledgements filed by one defendant and none by another.
So the one I'm looking at is at D for Daniel 110, defendant's name Gold CA, Vanessa Teresa Schwark. So
I see that. So that covers both of them, does it? All right.
I believe so. That would need defendant's counsel to confirm that, but that confirms that they intend to defend part of the claim.
But which part and why? On what basis?
I have no idea.
Well, we don't know what the dispute is. How can we answer the questions posed by Rule 20.7? Bit of a problem, isn't it?
I do understand that. However, I would say in order to resolve this dispute when it's clarified, it will require all related parties.
But that begs the question of what the dispute is.
And again, we're in this
where it's an endless circle, isn't it?
Yeah.
Is there anything else you want to say, Mr. Hutton?
Well, as I mentioned earlier, I would like to take you through the reasons for the joinder. However, I see no point if we can't get, in your mind, sir, if we can't get past this element of the dispute.
My problem with that is I'm happy to. I'm not going to. If you run the case however you want, Mr. Hutton, but when you do take me through that, I'm going to ask you, when you take me, for example, to clause 20.7 and 1 and say it's desirable to add the new party to the court so the court can resolve all the matters in dispute in the proceedings, I'm going to ask you, well, what is the dispute in the proceedings, so that I can work out whether the joinder of these parties will resolve all the matters in dispute.
Yeah, which
and you're not going to be able to answer that question.
Exactly, so, and I am certainly not one to demand my airtime, Your Honour. So,
well, it's, as I say, it's entirely a matter for you as to how you run your case.
Which I appreciate, but in these circumstances, we're going to end up back at this exactly same point. And I think Your Honour has made it quite clear in the position on Nest Investments and Rule 20.7. So that is understood, and we'll always end up, I think anything I would say would be along those lines, and we'll end up back at this very same point.
Yes, all right. All right, there's nothing else you wish to say there, Mr. Hutton?
The only other thing I wonder if we get clarity on, but it relates to signatures by the proposed defendants and the third and fourth defendants. So if they are not involved in this case at this point, you know, they're not relevant. It's just around the signatories and whether Mr. Pakshirajan is or is not a signatory to the audit confirmation sheet.
Sorry, I'm not understanding that. What's the significance of that? Where does that? How does that affect anything?
Well, it affects us in terms of whether it's desirable to add them as parties.
Right.
But again, I understand related to that same dispute point.
All right. Okay. I'll follow that then. All right.
So on that basis, I guess nothing further, Your Honour.
All right. Ms. Corella, I don't think I need to hear from you, but there are two applications before the court. There's your jurisdiction challenges. You accept that they should be, they're premature, aren't they? They should be dismissed.
100%, Your Honor. Actually, the same case, it's filed in Dubai court, and when the claimant he tried actually to double the jurisdiction, which is not allowing. And we deny any knowledge of any document or any relation with the document signed between the claimant and the defendant, the first defendant.
Yes, all right. Well, I think what I should do then is that I should dismiss the application for joinder for reasons to be public. I think I need to write reasons for the views that I've come to, but I don't think I should hold up delivery of the decision until those reasons are ready. So what I'll do is I will order now that the application for joinder be dismissed. I'll also order that the applications with respect to the jurisdiction of the court are also dismissed. In relation to the application for joinder, the time within which to seek permission for leave to appeal will not commence to run until my reasons are published. And I don't know when that will be, Mr. Hutton, because I've got a few other things on, but I'll try and get to them as soon as I can. But you won't be prejudiced, because if you wish to take the matter further, you can take it. Time will only run when you get the reasons. And what should we do on costs, Ms. Corella?
I think the claimant should pay all the cost of these sessions, Your Honor.
Well, I don't see why the claimant should pay the costs of your jurisdiction applications, because they shouldn't have been made, frankly.
But we will submit, Your Honor, our cost in this case to the court as soon as possible.
Right. Well, you haven't done that yet, so I can't fix the order. So all I can do is, Mr. Hutton, you can't resist an order that the claimant pay the third and fourth defendants' costs of the joinder application to be assessed by a registrar of the court if not agreed, can you?
No, I don't believe so, sir.
Yeah, all right. All right. Well, they'll be the orders then. And as I say, I'll get around to my reasons as soon as I can. But
understood. And may I just clarify?
Yes.
Your Honour, my instructions were to seek leave to appeal today, but given your statement, we can seek leave to appeal in due course.
I think you should get the reasons, and then you've got something to fight with then.
Excellent.
But I will certainly make it clear in the order that time will not run for the purposes of application permission to appeal until you get my reasons.
Excellent. Thank you, sir.
Okay. All right. All right. Well, if that's enough, those will be the orders. They'll issue, and I'll get my reasons to you as soon as I can. Thank you, everybody.
Thanks, sir. Thank you, Ms. Corella.